Good morning, everyone, and welcome to our first employment law seminar of 2021. Thank you for joining us this morning. My name is Marty Rabinovitch. I am a partner at Devry Smith Frank, and I head up the employment law group. So once again, welcome. Okay, so for human resources professionals who are attending today, the program has been approved for CPD hours through the HRPA. So after the presentation, please make sure you have your code, which I think you need in order to claim your hours. And for the lawyers who might be attending today, the program has been approved and qualifies for 1 hour and 30 minutes of substantive CPD content through the Law Society. We are going to cover 3 topics today. The first topic is mandatory COVID-19 vaccination policies in the workplace, tips and considerations for employers. The second topic is, are the SERB and other COVID-19 benefits received by an employee repayable upon settlement of a wrongful dismissal claim? And finally, we will look at the impact of COVID-19 on determining an employee's common law reasonable notice period. So here is an overview of the agenda for today. So you'll see that we have about 20 minutes per topic allocated here. I will tell you right now that the first topic is a little bit longer, and the topics do get progressively shorter. But the content is about an hour. We will then take a break at 10:05, and then we'll come back at about 10:15 for a Q&A period. So on that note, please feel free to enter any questions that you might have through GoToWebinar, and then I will review your questions at the break, and we'll come back and answer as many of them as possible before we wrap up at about 10:30. Now, on the topic of questions and answers, the most frequently asked question that I think we have gotten in past seminars is whether or not the slides will be available. And the answer to that question is absolutely yes. They will be posted on our firm's website at some point after the presentation. But if you would like to have them in your possession even sooner, feel free to send me an email and I will happily email you a copy of the slides. So let's get right into this, and we will talk about mandatory COVID-19 vaccination policies in the workplace. So here is a short overview of the presentation. I'm not going to go through this slide. This is more just for your reference. All right, so before we start talking about mandatory vaccination policies, I think it's important to think about the framework and just to pause to recall that there are other areas in society where vaccinations are required. So for example, schools in Ontario, also New Brunswick, but we'll focus on Ontario for now. Children and adolescents attending primary or secondary school in Ontario do have to have proof of immunization against a whole bunch of diseases that are set out in the statute and the regulations. There's a whole list of them here. And there is a penalty that is imposed by the statute called the Immunization of School Pupils Act, which is up to $1,000 for failure to comply. So it's not a particularly significant penalty, but there is a penalty nonetheless. So in Ontario, if we look still at the Act here, there is a duty that is set out in the Act, but there is also an exemption. So under Section 3 sub 1, the duty of a parent to vaccinate a child basically does not apply if the parent completes what they call here an immunization education session with a medical officer, okay, and if they file a statement of conscience or religious belief. So there is essentially an exemption based on conscience or religious belief. And the other exemption that's possible with respect to mandatory vaccination here is a medical exemption. So if you have a physician who believes that the vaccination would cause some other illness or could aggravate a pre-existing condition or symptom, there would also be an exemption. But in this context, subject to those exemptions, vaccination for those diseases is mandatory. Now, when we're talking about mandatory vaccination policies, it's also helpful to understand some of the policy arguments, or at least think about them when you are drafting a policy. So the first bullet here, it says many people are dying to get vaccinated while others would sooner die than be vaccinated. So if we have a whole bunch of people in society who would happily take a vaccine today if it were offered to them, while you've got other people in society who have been offered the vaccine but have not been, then so this argument goes, well, maybe we should just be making everyone get it if people who are offered it or who probably should be getting it are not. Now, this fact here is a little bit disturbing to me. So roughly 1/3 of staff in two major Toronto hospitals, so we're talking the University Health Network and Sunnybrook Hospital, are not vaccinated despite being offered priority to the vaccine. And you would think that in the health context, that number would be a lot higher. I mean, it would not be 100%, but certainly a lot higher than that. So if this is any indication of the number of people who are going to voluntarily get a vaccine, this number, if we extrapolate it to society as a whole, may not be enough to get us to those herd immunity numbers that we've been talking about. So the argument goes, well, if not enough people are voluntarily getting it, then maybe we should make it mandatory. Another argument that has come up is, well, we don't seem to have a problem with taking steps to achieve a smoke-free environment. So why should taking steps to achieve a COVID-19 free environment be any different? Now, there was a little bit of backlash when the anti-smoking legislation was introduced in the province, which effectively banned smoking in indoor spaces. There was a bit of backlash about that at first, but now we just sort of accept it. So I mean, if someone goes to a restaurant now, I mean, they can be assured that it's a smoke-free environment. So should they also not have the right to be assured that people in that environment are vaccinated, so their risk of contracting the virus is very low? It is possible that the Canadian government may prohibit the entry of foreigners into the country without proof of vaccination. We don't know exactly how our government will handle that yet, but I think this is a possibility. And certainly if this is the case, then should we not have the same vaccination standard for Canadian residents? Arguably, it should be mandatory to have a vaccine if you are going to be entering a senior citizens home or old age home, or coming in contact with at-risk individuals. And finally, back to the immunization for students case. Well, if we accept that there are certain contexts when immunization should be mandatory, why would this not be one of them? So those are some of the arguments to keep in mind when thinking about this issue. Now, there's currently no case law that I'm aware of that is definitively going to say, well, this vaccination policy is enforceable, this one's not, and here's why this one is enforceable and this one's not. I'm not aware of any cases that address that head on today. But what it's going to come down to is effectively a balance of two competing interests. So on the one hand, we have the employer's obligation to provide a safe workplace, and that obligation is set out in the Occupational Health and Safety Act, for example, as well as other employment and labor statutes. And then that right, the employer's obligation, is going to compete with the employee's refusal to get vaccinated, which may be due to a human rights code ground, it may be due to a medical reason, or it may be due to a personal opinion or personal preference simply not to get vaccinated. So I think it goes without saying that you can't really force someone physically to get the vaccine, and I don't think that's what our government has in mind. So what can we do about this as employers? So in certain circumstances, it may be possible to refuse hiring unvaccinated job seekers or those who have made it very clear that they will not get a vaccine for whatever reason. Given that the reason for that is going to probably result in a different outcome, and the nature of the workplace is going to affect this. If you as an employer are considering not hiring someone just because they've said they will not get vaccinated, I would get some legal advice first. You have to tread a bit carefully there. Now, it might also be possible for employers to introduce certain requirements for employees who refuse to get vaccinated. So if it works, an employee says, well, I'm not getting vaccinated, an employer could say, okay, well then, you're not allowed to come to the office. You're just going to work from home until either the pandemic's over or until you change your mind and just get vaccinated. Other examples would be making or requiring that employee to adhere to strict social distancing requirements or wear their masks either more often or in more spaces. Termination, again, I'm going to say proceed with caution here. You have to be very, very careful, before you fire someone just because they're not going to get vaccinated. I'm not saying it's impossible, but really you should proceed with caution and not until you obtain some legal advice. Now, we've alluded to this a little bit, but the enforceability of an employer's mandatory vaccination policy is going to depend on the nature of the workplace. So if we look at some of the examples here, if we have an office setting and most employees there have their own space or their separate office, and an employee says, well, I'm not getting vaccinated or I can't get vaccinated, because my doctor says that, it could aggravate a pre-existing condition. Well, probably in an office setting, there may be an accommodation possible. You can assign that employee their own space. You can make it very clear that they have to distance, they have to wear a mask, and so on. At a call center where an employee can basically make calls and answer calls from home, well, I mean, if the job is going to be from home and the employee is refusing to get vaccinated, for any reason, then probably that employment can still work if the employee can 100% do their job from home. Other settings are more complicated. So if we look at factories, hospitals, and restaurants, restaurants, there are steps that employers can take to limit capacity, but working in a restaurant probably can't guarantee that everyone is going to be physically distanced at all times. Employees are coming in contact with the public, they're coming in contact with each other. So I'm not saying it's impossible to accommodate there, but the employer's case for a mandatory vaccination policy in a restaurant, I think, is going to be a little bit stronger. Same thing, with the hospital. Hard to guarantee distancing. You're coming in contact with the public. If the public, is coming to the hospital, should they not at least, have the right, to be, protected from COVID-19, at least to the levels that the vaccines can protect us. So the nature of the workplace is going to be very relevant in this analysis. So here are some of the other factors for employers to consider. So are the employees going to be exposed, to COVID-19 patients, or the employees themselves at a higher risk of contracting the virus? or to high-risk individuals? Can the employer accommodate the employee while at the same time maintaining a safe workplace? Is there a balance to be found there? The reason that the employee is refusing to get vaccinated is also very important. If it's a personal belief or preference, that's going to be treated differently than a medical ground or a human rights code related ground. And another issue that is going to be relevant, so again, thinking back to this, employee rights, not to get vaccinated or preference not to get vaccinated versus the employer's right to keep a safe workplace, another factor is going to be, well, how effective is the vaccine? Now, we have data about that today. We have a sense of what it is, but what if there is new or changing data that becomes available? That could absolutely shift the balance. So, for example, if we look at the AstraZeneca story with the blood clotting, with the very rare blood clots. So at first, this was not a known risk at all because it was not picked up on in trials. And then, several months down the road, people were noticing it. So it was an issue that was getting looked into. And now, again, I believe we have our first case of this blood clotting from AstraZeneca in Canada. But, the line still seems to be that, yes, it's a risk, but it's a very low risk. So all of those three things are different developments, which could arguably shift the balance at any point in time in terms of whether an employee could be required to get, say, that AstraZeneca vaccine specifically, or I suppose Johnson & Johnson, because the same issue, I think, is coming up with that vaccine too. The Ontario Human Rights Commission, which investigates human rights issues and comes up with human rights policy, their chief commissioner in March of 2021 made the following statement about mandatory vaccination policies. Requiring proof of vaccination to ensure fitness to safely perform work or protect people receiving services or living in congregate housing may be permissible under the code if the requirement is made in good faith and is reasonably necessary for reasons related to safety. So there you go. The chief commissioner of the Human Rights Commission says that this can happen, at least in certain circumstances. Okay, so in terms of future enforceability, we touched on this a little bit. So the information that we have today is good, but it's going to be an evolving situation, and this can quickly change the balance between workplace safety and the employee's preference not to get vaccinated. We talked a bit about blood clotting and AstraZeneca already, so I'm not going to talk about that again. But what if it turns out that the vaccines that we have turn out to not be as effective as we thought they were? Or, what if it turns out that, they're particularly unsafe, for a certain age group? Okay, if the risk associated with the vaccines themselves becomes greater, that's going to improve the employee's case at the expense of the employer's. But what if the reverse is true? Well, what if the vaccines are shown to be even more effective at preventing, serious COVID or death, and that the side effects are minimal, or have an even lesser chance of occurring? If the reverse is true, well, then the employer's position is going to get better. So I want to go through some specific considerations for unionized workplaces for everyone out there who might be working at a unionized workplace. So in the unionized context, it is going to likely be more difficult to implement and enforce a mandatory vaccination policy. You may get a union who agrees, but I'm going to say they probably will not agree in most cases. So you have to assume as a unionized employer that the union is not going to voluntarily agree to such a policy. If the union will not agree, they'll say, well, we'll encourage our members to get vaccinated, but we don't support the employer effectively telling our members what they have to do. The employer may be able to implement such a policy under the management rights clause contained in the collective agreements, which, among other things, does permit employers to introduce policies. But there are specific criteria that would need to be followed, okay, in order for the policy to be upheld. And there are 5 considerations that are set out here. The case references are cited below. It comes from cases called Lumber and Sawmill Workers Union, and from the more recent Supreme Court of Canada case called Irving Pulp and Paper. But the 5 considerations are, first of all, is the policy consistent with the collective agreement? So if there's a management rights clause in there, is it a reasonable exercise of management rights? Is the policy reasonable? Is it clear and unequivocal? Was it brought to the attention of the employees before the employer attempts to act on it? Where the policy is relied upon to justify termination, was the employee told that a breach could result in a termination? And finally, has the employer enforced the rule consistently since its introduction? So the bolded 2 factors here tend to be the ones on which these cases turn. This is a bit more on management rights here. So this is also from Irving Pulp and Paper. Management does have a right to make and implement decisions, policies, and conditions, so long as this right is exercised reasonably and in a manner consistent with the collective agreement. Okay, so if as an employer, you do make the decision to introduce a mandatory vaccination policy, what sort of content should be in there? So first of all, I'm going to suggest some sort of exemption that's comparable to those contained in the Immunization of School Pupils Act, to accommodate for human rights code concerns, so that there should be some exemption for things like medical reasons or religious belief, maybe conscience too. It doesn't mean necessarily that anyone who has one of these grounds for not getting vaccinated is absolutely required to work without being vaccinated. It just means that the employer is going to have to search for an accommodation with the help of the employee in that situation. And maybe there will not be an accommodation, and we'll get to that in a second. I would also suggest having something in the policy which says that employees should advise once they are vaccinated. So that way, if the employer knows when they are vaccinated, the employer is able to be current on what the level of their risk is in the workplace. So if you've got, say, 200 employees in your workplace, but only 20 of them are vaccinated, well, you probably need some fairly strict COVID-19 protocols right now if you're going to be in the office. If you have 180 of your 200 members vaccinated, well, I mean, then you might look at relaxing things a little bit, when they're fully vaccinated. Another item to include would be requiring employees to tell you if they don't intend to get vaccinated, and if they don't, they should explain to you why. That should result in some discussion, and that way the employer can determine whether they should be looking to accommodate, or whether the reason for the objection is not good enough, and the employee should be required to get vaccinated. In particular, if you are dealing with a workplace that is difficult, for people to distance and whatnot. And then the policy should make it clear that the employer does intend to comply with the Human Rights Code and accommodate up to the point of undue hardship. Now, undue hardship is a very high threshold to meet. The only factors the tribunal will consider in that regard are cost and health and safety issues. But if it is just not possible for an employer, given a particular workplace, to permit an employee to work unvaccinated, then the idea of undue hardship would be triggered and the duty to accommodate under the code would end. Some additional practical considerations here. So most people don't like being required to take certain actions, in particular, a medical decision. So mandatory vaccination policies could in fact result in more opposition from employees who are undecided. So some employees will get the vaccine regardless of what the employer says. Others, will just not. But you will have some employees who might be unsure or will say, well, I'll get it eventually, but, just not now. There will be some level of uncertainty. Okay. If an employer introduces a mandatory policy, sure, some of those employees will say, okay, well, I wasn't sure, and now my employer is telling me I have to, so I guess I'll just go. But some of those employees may not be pleased with the manner in which the employer dealt with that issue, in which case the relationship between the employer and the employee could be a little bit strained. Now, for employers who are considering these policies, the goal really is to have as many employees vaccinated as possible to achieve what I'll call workplace herd immunity. So I would suggest that more employees may actually be willing to get vaccinated if they are simply encouraged rather than required to do so. The employer could also think of its role as an educator here. So if the employer should have information about benefits of vaccines readily available, and that information can be posted on the company intranet, sent to employees to address issues of vaccine hesitancy. So that way the employer could achieve its goal a bit better of getting more employees vaccinated. Now, if you have a sort of voluntary, I'll call it a voluntary with encouragement policy, but you've implemented that and the vaccine's available to everyone now, but you've still only got 50 of your 200 employees vaccinated, then maybe as an employer you may need to revisit and consider something more mandatory. In the future, when boosters are likely to be needed, it's a great idea to arrange for booster shot clinics when it's available at the workplace. I know that many employers do annual flu shot clinics as well. So if you bring the vaccines to your employees, more people will get it. And the government right now is talking about sending mobile vaccination clinics to certain employers who are in high-risk areas. So if your employer is in a high-risk area and the nature of the workplace makes it a bit more high risk, so if you're a restaurant or you're a factory or you're an Amazon warehouse, for example, I would encourage you to contact the government, explain your situation, and maybe the government will send eventually a mobile vaccination site right to your office, which should boost your workplace's vaccination numbers. Okay, so that concludes the topic on mandatory vaccination policies. And I'm going to move now right ahead into the next topic. We're changing gears a little bit here. And this is the topic about whether the SERB and other COVID-19 benefits received by an employee are going to be repayable if they settle a wrongful dismissal claim. So here is a brief overview of this topic. All right, so some of the background to this question. So employees who were laid off due to COVID-19 may have received a number of COVID-related benefits from our government. One is the SERB, the Canada Emergency Response Benefit, and another one, the SERB is now finished. The equivalent now to the SERB is the CRB, or the Canada Recovery Benefit. So employees who are not working right now or who have reduced hours because of something COVID-19 related have likely received those benefits. But we're going to look at how these benefits impact the employer's severance liability to the employee. And then later in the presentation, we'll look at whether these benefits might need to be repaid. So one of the questions here is whether SERB is comparable to income earned from another employer, which is also known as mitigation income. And mitigation income, as you can see from the next bullet point, effectively would reduce an employer's liability with respect to a common law reasonable notice period. Or are we treating it like EI, employment insurance, which typically would be repayable in the event of a wrongful dismissal settlement where funds are payable as wages or as a retirement allowance? Now, with respect to EI, and there may be a bit of a change, and I'll get to this, but historically, if an employee had received EI and they then received a severance payment from their employer, which was characterized as wages or retiring allowance, then the EI would be repayable, but that would not reduce the employee's common law entitlement. So the employer would still be liable for the full severance package, but then it would trigger a repayment of EI for the employee. So let's get into some of the cases that illustrate this a little bit. So the first case we'll look at is called Iriotakis and Peninsula Employment Services Limited. So in this case, Mr. Iriotakis was terminated from his employment without cause on March 25th of 2020, and he was 56 years old at the time. He had a sales position, and which involved working largely from home or on the road. And the majority of his compensation was commission-based. So his base salary was $60,000, but his compensation for his last full year was just over 145. So he's making about $85,000 in commissions, which is more than his base salary. So after the termination, March 25th of 2020, he manages to find a new job on October 19th of 2020, so just under 7 months following the termination. Okay. So one of the issues the court considered here was whether the SERB payments received by Mr. Iriotakis during the notice period would impact the severance package owed to him by the employer. And the answer in this case was no, there was no impact. So in this decision, the court highlighted a number of differences between EI and SERB, and some of those differences are summarized here in this chart. So EI is a long-standing program that's been in Canada for a while, and it's governed by an elaborate statutory regime. And it's absolutely true. The Employment Insurance Act is very, very long and detailed. On the other hand, SERB was an ad hoc program. So SERB was basically introduced, I'll call it, fairly quickly, fairly suddenly in response to a very specific set of circumstances. For EI, the employer and the employee are required to pay into the program. But for SERB, no one paid into it. You were just eligible for it based on certain criteria. And then for EI, the entitlement can be considered to be earned by the employee's contribution, but for SERB, the employee has not earned an entitlement beyond their general status as a taxpayer of Canada. One of the case-specific considerations here, which the court found to be relevant, was that the level of benefit paid, so $500 a week or about $2,000 a month for the SERB, was considerably below the employee's base salary and total annual earnings. So if you'll recall, the base salary was $60,000. So $2,000 a month, that's only $24,000. Okay. So the court concluded On balance and on these facts, I am of the view that it would not be equitable to reduce Mr. Iriotakis' entitlements to damages. So in other words, the employer has to pay out the same severance package despite the fact that he received the SERB. So what can we take from this case? So it's clear, at least the court really highlighted, that the SERB and the EI are different. It suggests that they should be treated differently, which further suggests that perhaps SERB is not going to be repayable upon a settlement, a severance settlement, unlike EI, which is repayable. Now, the other question that the case raises is, well, would the outcome have been different if the employee's income had been lower and closer to the amount of SERB payment received? So if the employee had been making about $500 a week or $2,000 per month, and then received almost exactly that amount, would the court have then said, oh, well, actually, there's no loss here at all, because instead of getting paid by the employer, now the employee is just getting paid through SERB? So it left that door open, but that question actually was addressed in the next case, which we'll look at, which is a decision of the 2021 decision of the Ontario Labour Relations Board called Shanna Marie Gray and Safecross. So this is another case about whether the SERB affects an employee's severance entitlement. So Ms. Gray began working at Safecross on October 15th of 2019 as a customer service and office support associate, and she was hired on a 12-month contract. She was terminated in August of 2020 for business reasons, and her salary, since apparently this might matter based on the last case, was about $37,000 per year. So we did the weekly here for you, about $711.54. So that number is actually a lot closer to the $500 weekly SERB benefits. So are we going to get a decision in this case saying, well, now it's basically mitigation income, the employer is entitled to a deduction? Nope. The Labor Relations Board says, nope, employer, you are not entitled to any credit for this SERB benefit. And the Labor Relations Board made that decision after specifically considering the decision in Iriotakis. And the court and the Labor Relations Board concluded the following. The board determined that the way to ensure that the employee is made whole is to require the employer to pay the entire amount owing. There will be no double award as suggested by the employer, as Ms. Gray may be required to repay any amounts determined to be in excess by the CRA. Ms. Gray should not have to bear the risk of not being whole as a result of the employer's reprisal. Accordingly, the employer's payment is to be made without offset or deduction for SERB payments received. So, what do we take from this case? Well, the SERB, we now have two cases saying this. The SERB is not going to be deductible from severance owed to an employee. We know that it is not mitigation income. Now, the board did acknowledge that the CRA might decide one day that the SERB may be repayable. And the board said, well, look, if that's the case, it would be unfair for the employee's severance to be reduced by that amount, because if we give the employer a credit and the CRA decides one day that the SERB is repayable, well, now the employee has lost out twice, once from the employer and once to CRA. So the board here has said, nope, there's going to be no deduction for the employer with respect to SERB benefits received. So now let's get into, let's hone in a little bit on when an employee could be required to pay or to repay the SERB benefit. So the government website says that SERB may be repayable if you return to work earlier than expected, including being paid retroactively. Okay, but being paid retroactively is not equivalent to receiving a severance package. Being paid retroactively is back pay. So for example, if an employee's wages were temporarily reduced during the pandemic, and then the employer, a couple of months later says, okay, well, business is now better, we can afford to pay you again, and the employer pays that additional back pay or top up pay, okay, and the employee had applied for SERB for that period. Well, now the employee has received some retroactive pay, and there may be a repayment entitlement there. And that example also applies to the next point here. The government website also says that SERB may be repayable if you earned more income than expected during the time you received the SERB payment. So if the employee was not expecting any back pay, but then all of a sudden business gets better and they are, okay, that is likely to trigger a repayment as well. Side note, SERB is taxable, but the government did not actually make withholdings on those payments. So the employees will have to pay tax on that when they do their 2020 taxes. The actual amount of tax payable at the end of the day will be dependent on how much income they have earned in total for that year. But let's look at a excerpt from the frequently asked questions about SERB, also on a government website. The question is, does being in receipt of severance impact a person's eligibility for the Canada Emergency Response Benefit? And the answer is no. Now, a frequently asked questions page on a government website is not a source of binding law, but it seems to give us a good indication of how the government and how the CRA is going to handle these issues, and this answer suggests that the SERB is not going to be repayable just because an employee has received severance. Now let's also look at what might be a new temporary rule with respect to the repayment of EI. This is another excerpt from the government's frequently asked questions page. And the question is, do any monies I received as separation when I was laid off affect the payment of EI benefits? I would have thought the answer would have been yes, it could trigger a repayment, but the answer, as you can see here, is no. As a temporary measure, most separation monies received when you are laid off will not affect the payment of your EI benefits for the claims established on or after September 27 of 2020 for 1 year. So I don't know, this seems to be saying that there's going to be an exemption from EI repayment in this circumstance for at least 1 year. So we are going to continue to monitor that to see if there's any additional decisions that come out or any additional postings on the government webpage. Okay, that concludes that topic, and we will now get into our third topic, which is the impact of COVID-19 on determining an employee's common law reasonable notice period. So here is a brief overview of this presentation. All right, so we'll start by looking at the impact of the employer's financial situation, and we'll start with a 2015 case of the Court of Appeal called Michaela and St. Thomas of Villanova Catholic School. So in this case, 3 teachers were dismissed by their employer, and in fixing the reasonable notice period, the court was asked to weigh in on, or the school said, hey, our financial situation is bad, we think we should be liable for a lower notice period. And the court in this case very plainly said, well, no, I don't really care about the school's financial situation. Just because you're saying the finances are bad, doesn't mean that, you owe less of a severance package. And similarly, if the evidence was that your financial situation is in fact very, very good, you wouldn't owe a greater notice period because of that. So no, the financial situation just doesn't matter. So we're going to look at, this issue in the context of the COVID-19 pandemic. So how that issue really translates, into employees is that, it comes down to, whether the employee is going to be able to mitigate and find a new job. So we're going back to the Iriotakis decision. The court, as you can see, decided a lot of issues in this case. And in this case, the court says, I was asked to make findings about the job market and the possible impact of COVID-19 on Mr. Iriotakis. I have little doubt that the pandemic has had some influence on Mr. Iriotakis' job search and would have been reasonably expected to do so at the time his employment was terminated in late March of 2020. However, it must also be borne in mind that the impact of the pandemic on the economy in general and on the job market in particular was highly speculative and uncertain both as to degree and to duration at the time Mr. Iriotakis' employment was terminated. I must be alert to the dangers of applying hindsight to the measuring of reasonable notice at the time when the decision was made to part ways with the plaintiff. So what does this all mean? So first of all, reasonable notice is to be assessed at the time the decision to terminate was made. Okay, it's not going to be assessed based on, what is known as of the day that the judge wrote the decision or as of the day that the parties were in court arguing it. You're fixing the reasonable notice period based on, the termination date. And the theory of wrongful dismissal law, or the common law at least, the theory is to ensure that an employee who was wrongfully dismissed will continue to receive their salary until such time as they're able to find a new job. But the court does make it clear that, reasonable notice is not going to be a guaranteed bridge to alternate employment. The termination here was really at the beginning of the pandemic, shortly after the first lockdown. And at the time of the termination, the extent of the lockdowns and the impact on businesses and the economy and the financial health of the economy generally was not fully known. So if the termination had occurred later in 2020, deeper into the pandemic, when we had a sense of what was going on, then perhaps a longer notice period may have been awarded because we would have had a better sense of the impact of COVID-19 on the availability of similar work. And then in another case that was also decided in 2021, the termination was August 28th of 2019. So this case, predates the pandemic by about a year and a half, I'll say. 11.65 years of service, 62 years old, director position. The court awards 16 months of notice at common law, and in doing so, concludes the following. It seems clear terminations, which occurred before the COVID pandemic and its effect on employment opportunities, should not attract the same consideration as termination after the beginning of the COVID pandemic and its negative effect on finding comparable employment. So there is an acknowledgement right there. There is an acknowledgement right there that, the pandemic, is relevant in that it will likely make it more difficult for employees to find a new job. And, will that result in longer reasonable notice periods? It very well might. We will know for sure once we get some decisions out where the terminations have taken place a little bit later in 2020, a little bit deeper into the pandemic. And again, we can see that the time of the termination is going to be the time that is relevant to the reasonable notice period and assessing the duty to mitigate. So the courts have acknowledged that there's going to be a clear difference between terminations during the pandemic, or at least deeper into the pandemic, versus pre-pandemic terminations. Now, despite this recognition that there are different circumstances in the pandemic, an employee still needs to make reasonable efforts to mitigate. Employees can't just sit on their couch and not do anything and say, oh well, the reason I can't find a job is because of the pandemic, and the courts have acknowledged that it's going to be very hard in at least two decisions. Well, no, the employee still is going to need to update their resume, update their LinkedIn profile, monitor, job postings, and so on. It doesn't change, what the employee is going to need to do in order to mitigate their damages. Okay, so this concludes the presentation here. It is about 10 to 10, and we'll take our break very shortly. But because I do have a little bit of time extra, it doesn't usually happen in these presentations, but we have a little bit of extra time here. I just wanted to bring a case to everyone's attention about termination clauses and the enforceability of termination clauses in employment contracts. So for those of you who have attended our employment law seminars in the past, you have heard me speak about the issue of termination clauses and their enforceability on many occasions, and I'm not proposing to do that now in the next 10 or 15 minutes. But what I did want to do was to bring everyone's attention to yet another case that recently was decided. It was decided on March 22nd of this year, so it's not even a month old yet. The topics for this presentation were already selected prior to the release of this decision, but this is a case about the enforceability of termination clauses. It is not particularly helpful for employers who do have termination language in their contracts. So I will tell you the name of the case. It's called Peretta and Rand Technology Corp. And Peretta, for those of you who are interested, is spelled P-E-R-E-T-T-A, and the employer is Rand Technology Corp. So Rand is R-A-N-D. So I'm not going to go into detail about the case, other than to say that I highly recommend that employers have their employment contracts reviewed, I would say at least once per year. And now that we have yet another decision, which is not particularly helpful to employers in this regard, I would suggest that now is a very good time for you to have your employment contracts reviewed. And that is something that I would be happy to help you with. So we're going to take our break in just a minute. So thank you to those of you who have already submitted questions. If any of you have any additional questions, please submit them right away through GoToWebinar, and I will take a look at them. So right now it's about 10 to 10. Let's take our break. We'll come back a little bit earlier. Let's take our break until 10 minutes after 10 o'clock, so 10:10. We'll come back then, and then I will spend about 20 minutes answering your questions. All right, thanks very much, everyone. Okay, thank you all for your questions. I've had a chance to go through your questions, and I will answer as many of them as I can in the next little bit here. So the first question was about the best sources of information available about vaccinations that an employer potentially could provide to their employees. So best information, most reliable information. I would say the information that you can find on government websites is probably the best and most reliable. And to the person who asked that question, I'm happy to speak to you and direct you to some good information about that. So I'm talking about information that would be on the Canadian government's website, the provincial government, so the Ontario government, and also the municipal government as well has some good stuff as well, depending on which municipality we're talking about. Okay, the next question is about whether an employer can require disclosure from an employee of whether they are vaccinated once they receive the vaccination, and whether they intend to get vaccination. Well, you can ask for the information. I mean, of course, you know, an employee might decide that they don't want to give it to you, in which case you'll have to decide as an employer what you're going to do with that. And, you know, probably you'll have to assume that they are not vaccinated and take that into account in terms of, you know, whether you need to make any changes in terms of the, you know, COVID-19 protocols in the workplace and whatnot. I personally don't find that request to be unreasonable. I mean, you may get some arguments from employees about, you know, privacy related legislation, and you may get arguments that, you know, this is really considered, you know, personal health information and it's not really the employer's business. That being said, I think that most employees would be willing to disclose that in, you know, the collective safety interest of everyone. So yes, I think it can be a good and effective strategy, but just be aware of some of what may come back from employees. There was a question about the slides. Yes, the slides will be available. They will be available on our firm's website, and if you would like them sooner, feel free to send me an email. I believe my email address is on the screen there. Feel free to send me an email, and I'd be more than happy to email you a copy of the slides. The next question was about an employer says that there is a managerial employee that they have at their workplace who has expressed an interest to move to a part-time role because of childcare reasons. The employer thinks that this is going to cause a difficult situation for them, potentially undue hardship. And the question is, well, you know, what are the employer's options in this regard? So there is a lot here, and the answer to this is likely to be different, you know, depending on, you know, what exactly the job is. So to the person who asked that, I'd be happy to discuss that with you over the phone. I mean, that's probably easiest for something like this. What I will say is that there are ESA leaves that are permitted for that are related to employees' childcare obligations that are COVID-19 related under the infectious disease emergency leave regulations. So that would be one issue that would need to be looked at. When you're looking at, you know, undue hardship, the only relevant factors that a court or a human rights tribunal will consider are cost and health and safety issues. And it is a high threshold. I mean, the other issue that might be relevant here is, you know, sort of whether the employer and the employee in this case is able to perform the basic duties of their job. I mean, if this is, you know, a very important role and it is a critical position, and, you know, the employee is only able to work part-time, then, you know, there could be an argument to be made that the employee is actually not, at least right now, capable of performing the basic duties of their job. So the answer to this question is going to be fairly fact specific. So I would encourage the person who asked that question to send me an email, get in touch with me, and I'd be happy to talk to you about that situation in a bit more detail. The next question was about an employer who says, well, if we reduced employees' salaries, including management, by 40% as a result of the pandemic, and then business picked up, and the company did get approved for the CEWS, or the Canada Emergency Wage Subsidy, would there be an obligation to make those back payments to their employees? I'm going to say yes, there would be. First of all, if there are employment contracts in place, verbally written past practices, that set out an employee's salary. If an employer doesn't pay the salary to the employee for any reason, that would be a breach of contract. So that's one reason for which the back payment would be required. And a 40% salary reduction is pretty significant. If any of those employees had advanced claims of constructive dismissal at common law, probably those claims would have succeeded with a salary reduction at 40%. So anyway, the short answer is yes, I would say from a legal standpoint, and also from an employee-employer relation standpoint, I would make those back payments. The next question was about examples of language that employers could use to encourage their employees to get vaccinated. Yeah, that is something that we could certainly help you with. And to the person who asked that question, I'd be happy to help you with that, come up with some language. So again, feel free to contact me. We also had some comments about the authorizations for the vaccines in Canada and how that might weigh into the analysis here. So the comment or the argument being made here was, well, if the vaccines that we're talking about in Canada, so for the Pfizer and Moderna and whatnot, if they're only authorized, with conditions, how possibly can an employer make those mandatory? And the second part of the comment was, essentially that certain jurisdictions are at least leaning towards not making COVID passports mandatory. So, how does that weigh in? Well, yeah. I mean, I would say sure. I mean, if employees are going to be disputing any mandatory vaccination policies, they may very well look at the fact that the vaccines have been authorized with conditions. At least that's the wording on the government websites. And yes, that would be a relevant factor in the analysis. The counter argument to that, though, is going to be that that the data that we have now is very, very looks very promising for these vaccines. And we are continuing to monitor that. But yes, those arguments are definitely valid considerations in terms of how the balance between the employee's rights and the employer's rights would play out. And the last question is about infectious disease emergency leave, and what does it mean if an employee is no longer going to be on infectious disease emergency leave as of July 4th of 2021. So basically, a little bit of a recap on that issue. So relatively early on in the pandemic, the government introduced regulations which basically said that if the employer lays off an employee temporarily or reduces their pay due to COVID-19, that the employee is essentially on a deemed infectious disease emergency leave, which is an unpaid job protected leave. So the length of that leave has been extended a number of times throughout the pandemic, and the most recent extension is to early July. So what it means is if an employee has not been brought back to work by July 5th of 2021, or pretty much the day after the leave expires, what it means is that their employment will be deemed to have been terminated, and they would be owed a severance package. The other comment I'll make about this issue is that is the Employment Standards Act scheme. An employee who has been laid off and has not returned to work yet may also have a claim for constructive dismissal at common law. But for the ESA, basically what it means, if you don't bring your employees back to work, by July 4th or July 5th, or the day after the date on which these temporary or deemed infectious disease emergency leave provisions expire, then there's going to be a deemed termination, and a severance package would be owed to the employee. Okay, so those are all the questions that we got. Thank you again for your questions. So we're going to wrap this up now. So thanks to everyone for attending this morning. I see there are still many of you here listening to all the answers to the questions, so I appreciate that. If you have any additional questions, or if you'd like copies of the slide, if you have any comments or feedback, any topics that you would like to see in our next employment seminar, please feel free to get in touch. And on the topic of our next seminar, we usually hold these every 3 or 4 months. So the next seminar is likely to be sometime in June, but we will certainly communicate that date to you as soon as we know it. Once again, thanks everyone for coming this morning. I hope you found today's session to be informative, and have a great day. Thanks, everyone.